for a minute during COVID,
Okay,
but we're really growing in Chicago.
if we could,
She's from there.
if people could come in and take their seats. This is just like law school. Everybody wants to sit in the back and by the door.
Yep.
Good evening, everyone. My name is Nick Borton. I'm the chair of the board of directors of the Office of the Appellate Defender, and it is my great pleasure to welcome you to the 30th annual First Monday in October. Thank you all for coming tonight and for your generous support of OAD. I have been on the board for almost 10 years, and I've served as the chair for the past 4. And I could not be more proud of this organization. OAD is a crown jewel in the criminal justice nonprofit world. The dedicated staff, and there are so many of them here tonight, fight every day for justice, and they achieve extraordinary results. That work would not be possible without your support of OAD and of First Monday in particular. And I have to say, we are quite proud of this event. We think it is the best fundraiser in New York City, hands down. And we're very confident that tonight's First Monday will not be an exception. We have a fantastic lineup, as you've seen, filled with superhero levels of legal talent. Our advocates and the recipients of the Gould Award for Outstanding Advocacy, Danny James of Kramer Levin, and also an OAD board member herself, June Kim of Cleary Gottlieb. As always, we make our Gould Award winners sing for their supper, and we know how much work they put into preparing the argument for tonight, and we are so grateful for it. Our Chief Justice and recipient of the Council for Justice Award, Christina Duggar of J.P. Morgan Chase. And our all-star cast of mock Supreme Court justices, Matthew Bybin, Russell Capone, Sarah Coyne, Soumya Dayananda, Elon Graff, Rachel Maiman, Mark Racanelli, and Sitha Ramachandran. We're also proud to present our annual Beacon of Hope Award to Ricardo Jimenez and the OAD Gideon Award to Oric. I want to thank all of our award winners and the justices for participating in tonight's event. This event depends on the willingness of many people, many very busy people, to dedicate their time and talent to the cause, and we are so very grateful. We also have a number of past First Monday honorees and justices with us this evening. Welcome back, everyone. And we're honored to have several members of the actual judiciary with us tonight as well. Thank you so much for being here. It is now my pleasure to introduce OAD's amazing president and attorney in charge, Caprice Jennerson. It is she who's going to run tonight's festivities, and she's going to tell you more about what you're supporting tonight, which is the incredible work that OAD does each and every day.
So as Nick was saying, to organize this event takes a whole lot of people and a whole lot of time. And I just want to take a moment and look out across the room at all the friendly faces and supporters and thank you for joining us tonight. I'd like to add a little bit to some of Nick's thank yous. For one, to all of the honorees and participants, I thank you for your participation. To our amazing host committee, who took a lot of phone calls and emails starting maybe 6 or 7 months ago to put this event together, Nick, Martin Bell, Sean Hecker, Joanna Hendon, James Lunam, Tatiana Martin, and Jeff Udell. And also I'd like to thank the entire board of directors for your support, not just for tonight, but throughout the year. Your support is greatly appreciated and deeply felt. For 30 years, our board member and First Monday court crier, Myrna Felder, has been a true gem, and we are so excited that she will continue tonight as court crier. We'd like to thank Appellate Innovations for producing our lovely journals that are on your seats. And again, we thank you for all of your support in making this night a true success. So this is really a special evening for us. Not only are we celebrating the 30th annual First Monday in October, but also OAD is celebrating its 35th anniversary. For more than 3 decades, OAD has breathed life into its mission to provide outstanding appellate representation to people who are indigent and convicted of felonies in Manhattan and the Bronx. We also strive to improve the quality of indigent defense representation through education and training, and we advocate for a systemic reform of New York City's criminal justice system. It is important to me to take a moment and acknowledge and thank my colleagues at OAD, and there's so many of them in the room. I am privileged to serve as the president and attorney in charge of OAD at this time in history, and to stand beside such smart and amazingly compassionate people who have dedicated themselves to public interest. So thank you to all of the OAD staff. There are so many cases where I am simply in awe of the creative and zealous advocacy of OAD attorneys, attorneys from the Volunteer Appellate Defender Program, or even students who participate through the Criminal Appellate Defender Clinic at NYU. And there's so many positive outcomes, and I'll give you just a few examples of things that I remember over the past year or so. One case where the Court of Appeals found a client's waiver of right to counsel made very early in the case, the court found was invalid. Another case where the First Department reversed a conviction for weapons possession, finding that the police committed an unlawful search and the stop was pretextual. Another case in the First Department where a conviction was reversed because the court found that the accused's right to counsel had been violated. Another case where the New York Supreme Court vacated, dismissed, and sealed 10 of our clients' convictions after finding that our client was the victim of sex trafficking. And there are so many other cases like that. I could probably spend the rest of the evening just talking to you about the work that the amazing attorneys at OAD are doing. But what we also recognize is our clients are whole people, and they require attention outside of the courtroom. And so we are pleased to have a client services team who address issues of rehabilitation and restoration for our clients in areas of mental health support, medical support, housing support, public benefits support. And I asked my client services team to give me some of the feedback that they've been hearing from their clients. And I want to read a few of the things that the team have received letters and cards from clients, and these are what our clients are saying. Thank you for articulating my journey and the person that I have become. After being granted parole after serving more than 27 years in custody, one client said, I couldn't rest since I got the great news that I've been granted parole. Once again, thank you for sticking with me and staying in my corner. You started this journey with me and you completed the journey with me. Another client expressed sincere gratitude for caring for me as a person and being sympathetic to my situation. I hold it dear to my heart because I know that you genuinely care and will forever hold that care close to me. So those are just a few of the things that we hear from our client, and there's so many more, but what it shows is that we value the dignity of our clients, and we try and make sure that we tell their stories in their way. Against enormous odds, OAD staff members work tirelessly to ensure fair and equal access to justice and erase the line between those who have and those who do not. They carefully tell the stories of the humans we serve in a way that maintains dignity and agency of every person. When I think of the staff at OAD, past and present, I am reminded of the words of the late Congressman John Lewis, who said, stand up, speak out, speak up, and get in the way. And I think the staff at OAD finds a way to get in the way every time. I am so pleased to announce that because of your generosity and support of OAD, we have raised over $575,000 tonight. Thank you so much for your support. Since 2018, OAD has awarded the Gideon Award to a law firm that has demonstrated exemplary commitment to indigent appellate defense through its participation in our volunteer appellate defender program. Attorneys at participating law firms get valuable hands-on experience on all aspects of criminal appeal, from issue selection to oral argument, all under the direction and supervision of a supervising attorney at OAD. Most importantly, OAD clients receive the support of dedicated associates and partners through the program. It feels like a full circle moment to present this year's Gideon Award to ORIC. It is a special moment, particularly because the award will be accepted by Joshua Rosencrantz, who serves as ORIC's head of Supreme Court and appellate practice. But Josh is more than a leader at ORIC. He is an OAD board member and the founding and first attorney in charge of OAD. And under Josh's leadership, the VAD program was established in 1991. ORIC has partnered with OAD in dozens of cases throughout its many years of involvement. ORIC is currently assigned 5 outstanding cases. In one of the cases, the trial judge had suppressed a client's statement due to a Miranda violation, but then allowed the prosecution to bring that statement in at trial after finding that the defense had opened the door. Well, ORIC has sprung into action and argued that that conduct violated Supreme Court precedent, which allows such evidence only where a defendant testifies in a matter inconsistent with the suppressed statement. The appellate division affirmed, and after extensive briefing by the ORIC attorneys and a leave conference with a judge in the Court of Appeals, the leave to appeal was denied, but ORIC is still working. ORIC has filed a federal habeas petition in the matter, and that case is headed to the Second Circuit. So we look forward to seeing the outcome in that case on behalf of the client. We are so grateful for this partnership with ORIC, and it is my pleasure to present the Gideon Award to OAD board member Joshua Rosencrantz on behalf of ORIC.
Well, thank you, Caprice. That was so lovely, and I guess the place I would start is by saying, I can't believe we founded OAD 35 years ago. I was 2.5 at the time, decades anyway. But when we founded OAD, we had 2 aspirations, really. One was just a complete commitment to excellence and to doing everything that we could for the benefit of our clients. And the second was a deep integration with the bar. And I remember when we were designing OAD, thinking, interviewing so many public defenders all across the country and realizing so few of them were integrated with the private bar. And we had this gut instinct that the integration with the private bar would make us stronger, both because of all the things that Caprice talked about that you just can't do with only government funding, but also because the private bar makes us better by integrating with us in cases. And both the First Monday event and the Volunteer Appellate Defender Program were born out of that aspiration of deep integration with the private bar. And so, yes, this is kind of a fun, full circle moment, because 30 years ago, I was standing on a stage like this, presenting these awards to the first recipients of the Gould Award. And now I'm just so honored to have ORIC, another institution that I care deeply about, being honored in the same way, and an institution that is equally committed to those 2 same aspirations, just to sheer excellence in doing everything that we can for clients and deep integration with the community of which we are part, which is what this award acknowledges. So thank you so much to OAD. Thank you all for supporting OAD, and thank you for listening.
So let me just tell you a little bit about the case that you will hear argued this evening. You are invited to read more details about the case in the Spectator's Primer in your journal. But just for a little background, tonight's advocates will argue the case of United States versus Rahimi. Following allegations that Rahimi had physically assaulted his then-girlfriend and fired a weapon at a bystander, a restraining order was issued against him, ordering him to stay away from that girlfriend for 2 years. He was also specifically ordered not to possess a firearm. Because he was being investigated for some unrelated offenses in the Arlington, Texas area, the police executed a search warrant on his home. Therein, they found a .45 caliber pistol, a rifle, and a copy of the restraining order that had been served upon him. He was charged in federal court with 1 count of possessing a firearm while under a protective order in violation of 18 U.S.C. 922 G8. After his challenge to the constitutionality of the statute was denied, he entered a guilty plea and was sentenced to 73 months in federal prison. In appealing his conviction, he asserted that the federal statute was unconstitutional. On appeal, the Fifth Circuit affirmed his conviction as his challenge was foreclosed by binding precedent. But while his rehearing was pending, the United States Supreme Court decided New York State Rifle and Pistol Association versus Bruen. In a 6-3 ruling, Bruen, the subject of this mock Supreme Court in 2021, struck down New York's century-old public carry licensing law and announced a radical new framework for evaluating Second Amendment challenges. As a result of the Bruen decision, the Fifth Circuit withdrew its first opinion and reversed the district court's decision. The court granted the government's petition for writ of certiorari on June 30th of 2023. The brief question to be decided by our esteemed justices is whether the federal statute, which prohibits a person from the possession of a firearm if they are subject to a domestic violence restraining order, is a violation of the Second Amendment and thus unconstitutional. So just a couple of notes in terms of logistics. We will move through the remainder of the program without intermission. After the oral argument by the advocates, Joanna Hendon and Lisa Vicenz will present the Gould Awards for Outstanding Advocacy to Danny James and June Kim, respectively, and James Lunam will present the Council of Justice Award to Christina Duggar. Then we will observe the deliberations of the mock Supreme Court. Fingers crossed, will end around 9 o'clock. So please take a moment if you have not done so already and silence your phones. Please join me in the courtroom of the mock Supreme Court of the United States as I invite the court crier, Myrna Felder, to open this court session. The time is 10 a.m. The day is the first Monday in October 2023.
Please rise. Justices of the mock Supreme Court of the United States. Oyez, 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 all persons having business before the mock Supreme Court of the United States, draw near and give your attention because the court is now sitting. God bless the United States and this honorable court. Be seated.
Thank you. The court will now hear argument in docket number 22915, United States versus Zaki Rahimi. Mr. Kim, we'll hear from you first.
Madam Chief Justice, may it please the Court. More than 1 million cases of domestic violence occur in America every year. That's 3,000 every day. Just during the time that we will spend together in this argument, in this beautiful, majestic hall, in over 300 other places in America, there will be domestic violence. In those places, it will be loud, unlike here. There'll be screaming, there'll be kicking, there'll be punching. Spouses literally will get beaten and battered. There will be grandparents, there'll be sisters, brothers, friends pleading for the violence to stop. And there'll be police officers called to help defuse the situation. There'll be children, some hiding in corners with their ears covered, praying for all of this to be over. And there'll also be children who will draw up all the courage they have to stand up against the bully. And in too many of these highly combustible places, there will also be guns. These guns brought into this mix will kill and have killed far too many innocent Americans. Every 16 hours, a woman is killed with a firearm by an intimate partner, every 16 hours. And the idea that our Constitution precludes and prevents us from keeping guns out of the most dangerous and volatile situations is madness. It's not just madness. Importantly, this idea comes from an improper reading of this court's precedents and hundreds of years of relevant law, practice, and tradition. This court has recognized that the Second Amendment right to bear arms, like other rights in the Constitution, has limits. It is not absolute, it's not unbounded. Not all people have the right to bear arms all the time. That is not and has never been the law. And this court's precedents have made clear that Congress can disarm people who are not law-abiding or responsible citizens. That's been made clear in Bruen, in Heller, and in McDonald. And it's a limitation that makes sense because guns are dangerous. And it limits the possession of guns to those who are law-abiding, responsible citizens. And that's consistent with the court's precedent. It's consistent with the court's finding in Bruen that there are categorical prohibitions that are presumptively constitutional. Felons in possession of firearms, mentally ill. Also, that it's presumptively constitutional to limit firearms from sensitive places. All of these, this court has held limitations on the right to bear arms that are constitutional. And this court has made clear in McDonald that this list is not an exhaustive one. So, not only has this court made clear that the right to bear arms is one that belongs to those who are law-abiding and responsible, it has, as the Bruen court has directed this court to do, it is consistent with the historical traditions and fits comfortably into the traditions that go back to Old English common law, which I had to read this weekend, that make clear that the disarmament of dangerous individuals, those who are not law-abiding and not responsible, that goes back to the Old English days of the Statute of Northampton, to the Militia Act of the 1662, the English Bill of Rights. I read all of them, including during the founding era. There were state statutes that precluded persons who were law-abiding, not law-abiding responsible persons from having weapons. And then following the founding era, there have been numerous statutes that similarly preclude gun possession from those who pose a danger to the community. Surety statutes are similar in that way. And all of these are a long line of a tradition of regulating gun possession that satisfies the standard that Bruin set forth in its recent decision. And that's the way in which the Fifth Circuit has erred in saying that 922G8 is unconstitutional.
Thank you, Mr. Kim. But can you tell us who decides what constitutes law-abiding and what constitutes responsible? Who makes that decision?
This court does, and courts do, and has traditionally done that all the time. So the legislatures can decide what laws they want to put in place to limit gun possession to those who are law-abiding and responsible. And the court has the ability to test those as it will and has done. But it's not a right that belongs to everyone. Clearly, the record has shown, and our history has shown, that those who are subject to a domestic violence protective order are those who are not law-abiding or responsible, whose limited deprivation of their right to possess firearms during the period of the protective order is a limitation that the Constitution permits, consistent with this court's precedent and consistent with the history that the court should look at if it follows Bruin's standard.
Following up on Justice Coyne's question, Mr. Kim, if you could just help me understand what the limitation of responsible adds. So you've said repeatedly law-abiding and responsible. What does it mean to be responsible? What are the limits of that? What could a legislature not call irresponsible such that they could take away guns, a citizen's guns?
Justice Breyer, law-abiding and responsible are not my words, they're yours. This court has repeatedly described the right of the Second Amendment to bear arms to those who are law-abiding and responsible. In fact, used that term over a dozen times in Bruin itself.
What did I mean?
I think you meant that it can be kept from dangerous people who pose a danger to others individually or collectively, and that is consistent with the long and deep-rooted tradition of keeping dangerous weapons from individuals who pose a danger to others, or from places that are sensitive and pose a danger to the public and to individuals.
Mr. Kim, isn't it true that the reference to law-abiding and responsible has been completely in dicta? In Heller, we defined the people as the entire political community. In fact, the word people is referenced in multiple amendments in the Bill of Rights. Is the people similarly only a subset of the people in each of those amendments, or is the Second Amendment different?
It's not dicta. Normally, this court doesn't repeat dicta 12 times over and over again in one decision, and repeat it in every decision that has addressed the Second Amendment. So respectfully, this court doesn't repeat itself that often in dicta. And so I don't think it's just dicta, and it makes sense because there's no question that the Second Amendment, although the Second Amendment, just like all the other amendments, are rights that need to be protected. It's a different type of a protection because guns are inherently dangerous. And so it makes sense that in the court's rulings and findings to date, it has limited that right to law-abiding and responsible citizens, i.e., in other words, not dangerous people and dangerous situations.
Speaking of dangerous situations, you look like a man who's ready for a 14-part pop quiz on English common law, which is not my question. Aren't you at all concerned that those terms, however frequently we have wisely used them, are troublingly vague? What if somebody who declines to mask during a pandemic, is that dangerous of a sort that they should be denied a fundamental constitutional right to guns?
No, Your Honor. This type of an analysis in interpreting words and concepts like dangerousness or irresponsible law-abiding citizens is the type of work that courts do all the time, and this court does all the time. That doesn't mean, as Judge Ho said in the Fifth Circuit decision, that someone who's got a speeding ticket is going to be taken, that their Second Amendment rights are going to be deprived of them. The standard obviously relates to the dangerousness that one poses, the possession of the firearm poses. So if a citizen is irresponsible and not law-abiding in the sense that they have established themselves as individuals whose possession of a gun would pose a danger. That would be the standard. So the idea that there's no limiting principle, if we allow what the court has been saying for decades and repeated 12 times recently, that law-abiding and responsible citizens are the ones who have the right to bear arms, that suddenly anyone who gets a jaywalking ticket is going to be deprived of that right. That's absurd. And the reality is it's the respondents' arguments and the Fifth Circuit's decision that has no limiting principle. If people just means people, meaning all people, then there'll be no basis to preclude or regulate firearms in any setting, whether it's schools, airplanes, subways, or felons or mentally ill. And that's clearly not consistent with this court's precedent or common sense.
Mr. Kim, we're relying a lot on this language about responsible citizens, but given what we refer to in Bruin as an
Your language, which is what we rely on.
Yes. Given what we refer to in Bruin as an unqualified command, shouldn't that language that we've been talking about be read for what it actually means, that the state can bar use of firearms in otherwise illegal acts, such as in Section 924C? Not just for not for particular individuals?
I'm sorry, the question is, should it be limited to what?
Should the language that we've been talking about, should it be read for what it really means, given what we said in Bruin about an unqualified command, that the state can bar the use of firearms in otherwise illegal acts, such as 924C?
That's not how the court has applied the terminology responsible and law-abiding citizens. It has applied it in the context of the scope of the Second Amendment's reach. It did so in Bruin in saying that the court has recognized the right to bear arms for law-abiding and responsible citizens. The court itself has never limited it in that way. And it makes sense because it's not a right that exists for everyone or every person.
Mr. Kim, you seem to be arguing that the law-abiding responsible person test is bounded, limited, if it's to be limited at all, by the concept of dangerousness. Where does that limitation come from, and how do you define dangerousness?
That limitation comes from this court's precedent as well as the history of regulating firearms possession, which is what the Bruin court has directed us to do, which is to look for historical precedents. And if you look at the historical precedents dating back to Old English law, to the founding years, and since, there have been limitations that have been tied to individuals who are dangerous and in circumstances that are dangerous, that are well in line with the statutes that issue today that the court needs to decide, which is 922G8, of individuals who are subject to domestic violence protective orders that have been issued only after an opportunity to be heard, after notice, and a finding essentially of dangerousness. It is in that setting that we believe that the court's precedent, its language, and its history of limiting gun possession to dangerous individuals and circumstances makes 922G8 constitutional.
But if a jurisdiction, I just want to get back to this tie between responsible and dangerous, if there is actually such a tie, and I don't see that there is one, but if a jurisdiction were to say if you fail to get a vaccine, that's irresponsible. If you fail to wear a mask, that's irresponsible. That reflects your judgment being flawed. We're going to deny you the right, your Second Amendment right. Would there be any limitation constitutionally in your interpretation and legislature's ability to do that?
According to the test that this court has set forth in Bruin, there would be a limitation, because if that were to be the limitation that's placed, the burden would be on the government or the state that wanted to enact that statute to find a relevantly similar statute that or prohibition that existed at the time of the founding, and it would be difficult. COVID having not been around back then, as far as we know, to find a relevantly similar statute. And it wouldn't tie to the dangerousness, the irresponsibility wouldn't tie to the potential danger that a possession of a gun would possess, which is clearly a link, if you look at the history and the precedents are clearly a link that you'd need to make.
Mr. Kim, I have one question. Can you talk about the restriction that is imposed, that it's temporary, right? So it only exists during the time that the order of protection is in effect. What happens when the order of protection is lifted? Does that person then become not dangerous?
Well, that may be that under the statute, it would only be restrain the possession of a firearm for those individuals subject to such an order while the order is in place. There obviously are, unfortunately, plenty of dangerous people out there and people who pose a danger to the community who have their Second Amendment rights unrestrained. And that would be the case for someone who is no longer the subject of a protective order. But that doesn't undermine or change the fact that the statute itself is limited both in terms of what's required in the finding and temporarily limited to the period under which the individual is subject to the order. I believe the light is red, so I will.
Thank you, Mr. Kim.
Turn it over.
We'll now hear from you, Ms. James.
Chief Justice Dugar, may it please the court. Well, the policy undergirding 922G8 is obviously a laudatory one. As this court has instructed in McDonald, in Heller, and most recently in Bruin, is that once a right is enshrined in the Constitution, that necessarily takes certain policy choices off the table. And under this court's precedents, the right to keep arms now stands on the same footing as our other fundamental enumerated rights. And just as Congress could not completely ban a person subject to a restraining order from petitioning the government, traveling, voting, or serving on a jury, the government cannot completely ban a person subject to a protective order from possessing a firearm, particularly in the home. Now, I understand the parade of horribles that my friend has pointed to, and no one is here contesting that domestic violence is not a serious problem. But just as we, many of us in this room, fight day in and day out to preserve constitutional rights, including some that may present a danger to the public. For example, critics deride this court's jurisprudence with respect to the people's right to be free from unreasonable searches and seizures under the Fourth Amendment, because the exclusionary rule does result in some violent offenders going free. We stand up for that right day in and day out. And the Second Amendment has now enshrined an individual right to keep and bear arms that is no less worthy of that protection.
Ms. James, could I ask a question about that? In this case, Mr. Rahimi's Second Amendment right isn't the only one that was abridged. The protective order at issue obviously put limitations on his First Amendment rights as well on the basis of a judicial finding. Are there similar limits that would have been permissible with respect to the Second Amendment? And if so, what limitation could have been placed on his right to bear a firearm without running afoul of our jurisprudence?
If I may beg your indulgence, I am going to answer your question, but I think it takes a few steps to get there. Mr. Kim spent a lot of time talking about who might be protected by the Second Amendment. I think the Bruin analysis makes clear that when the plain text of the Second Amendment covers conduct, and the conduct at issue here is quite clearly possessing a firearm in your bedroom, then the Constitution presumptively protects that conduct, right? And only if there is a long-standing tradition of regulating a firearm can the regulation withstand constitutional muster? And I'm getting to your question, Your Honor, and thank you for your indulgence. When we look at history and tradition, I think the only analogous statute we can point to, and which Mr. Kim referenced here, but I respectfully submit it doesn't satisfy the Bruin standard with respect to 922G8. But the only relevant analog are security laws that existed around the time of the founding, both before and after ratification. And those laws, much like a civil protective order, allowed someone to come to court and present evidence that an individual posed a danger. And if the justice of the peace was so satisfied, the justice of the peace could do something, but it wasn't banning possession of the firearm. That was not the route the founders chose to deal with the threat of interpersonal violence. Rather, all that was allowed was for the justice of the peace to require the respondent to post a bond if the respondent wanted to carry the firearm in public. The security laws say nothing about absolute bans on possession of firearms within the home. And I think, although Mr. Kim alluded to long-standing traditions, I'd actually like to talk about what some of those were, because I think it relates to this question of who is afforded rights under the Second Amendment.
Ms. James, before you get to that question, let me ask you, does Bruin foreclose any gun regulations that didn't exist at the founding, according to your argument?
What Bruin instructs is that in order for a firearm regulation to survive constitutional scrutiny, you must find a historical analog. And when looking at that analog, we have to examine the why of the longstanding tradition and the how of the longstanding tradition. That underlines 922G8, but it doesn't comport with the how. And so the question is, are there firearms regulations that comport with the how of what we've seen historically? There may be some, but 922G8 is not one because it is a total ban on possession of firearms, including in the home. And I submit there hasn't ever been such a ban on possession of a firearm in the home for persons who are considered a part of the political community.
Ms. James,
hold on. The concept, the limiting concept that you seem to accept is that felons, convicted felons, can be dispossessed of firearms. Is that correct?
I don't think this court has ruled on that proposition yet under the Bruin analysis.
Is your argument that that is an open question as well, then?
While Heller says in dicta that the decision should not, cast doubt on longstanding traditions of regulating firearms, such as prohibiting bans on felons and the mentally ill, that language was not necessary to the decision in the case. And I will say that in cases pre-Bruin and post-Bruin, courts have grappled with the question of whether there is, in fact, a longstanding tradition of banning felons. And I think the evidence is inconclusive, but that is not the case that's before the court today. And even if this court were to find that a felon in possession statute was constitutional, Mr. Rahimi was not a felon at the time he was prosecuted under this statute, nor was he alleged to have been or ever adjudicated to have been suffering from any mental illness.
Ms. James, you say that there are no historical analogs. In your view, does the analog need to specifically pertain to domestic violence? In other words, for a couple of hundred years, states have restricted possession of firearms by underage individuals, people of unsound mind, vagrants, people that you would think would be dangerous with the firearm. Why are those not sufficient analogs? In Bruin, we said that the analog needs to be, I think, similar, but not a twin.
That's right, Your Honor. Bruin does not require a twin. It only requires a similar analog that has the same why and the same how. And with respect to your question, I think if we look at the body of law that Mr. Kim was referring to, none of that body of law actually satisfies this standard. For example, the government relies on the so-called going armed laws, right, where people who were carrying firearms in terroristic ways and threatening the public could have those firearms forfeited. That's not what this statute does. The going armed laws were criminal prohibitions against the manner in which weapons were being used and carried. This statute here applies whether you use the firearm or not. It punishes mere possession. And even with respect to the going armed laws, notably, not all of them required actual forfeiture of the weapon upon conviction. People were just sentenced for their misuse of the firearm, which is something that no doubt can be constitutionally done today. Likewise, the other laws upon which the government is relying are similarly dissimilar and don't support their position here. Although the government says there's a long-standing tradition of prohibiting possession by dangerous people, what most of those statutes really were laws banning firearms possession by Black people, Native Americans, Catholics, people who were not deemed to be members of the political community. Now, the government before this court has rightly dropped their reliance on those cases as the relevant history, but instead they're relying on laws banning possession by people who were deemed to be loyalists to the crown. But there too, that prohibition is more about who's in the political community and who's not in the political community.
Ms. James, just to follow on that, definitely not in the political community at the time of the founding were women, correct?
That is correct.
And you would agree with me that the majority of the victims of domestic violence in this country are women, correct?
I assume that is the case.
So are they just out of luck because they can't find a fraternal or identical twin analog from when they didn't have a voice in the government?
No, Your Honor, absolutely not. And there are two points I'd like to make in this respect. First, again, I think the narrow frame of domestic violence is not the right frame. The question is interpersonal violence. Having said that, while certainly domestic violence was not treated with the care it warranted at the time of the founding, it wasn't wholly ignored. There were private and public prosecutions for spousal abuse at the time of the founding. People could also avail themselves of the surrogate laws to seek some extra protection against their partner from carrying a weapon without some oversight by the local justice of the peace. So it was not a problem that was ignored or didn't exist at the time of the founding. And as Bruen instructs us, that where there is a long-standing problem that has been addressed in materially different ways, that supports the finding that the modern firearms regulation doesn't survive constitutional scrutiny. Now, there's no doubt that this might take a tool out of the toolkit for combating domestic violence. Again, maybe not the policy choice that people in this room might make, but the enshrinement of the right to bear arms in the Constitution, as interpreted by this court, now takes that policy choice off the table. That doesn't mean that people cannot be prosecuted for their violent offenses, and they absolutely should be.
Ms. James, with respect to the question of whether this is a restriction that is sufficiently rooted in the history and DNA of the country, is it meaningful in your view that half the states have similar restrictions like this on their books, including some very gun-friendly states like Florida and Alabama?
Your Honor, while that might reflect today's consensus, I think what Bruin instructs is that not all history is equal for purposes of this analysis, and we're to focus our analysis around the time of the founding to understand the right as originally conceived and enshrined in the Constitution. And measured against that standard, that we now have come to a different view, doesn't really impact the constitutional analysis.
Ms. James, could you ever find a historical analog for conduct like domestic violence that wasn't criminalized at the time, or at least was more widely tolerated?
I'm not sure I understand Your Honor's question, because violent conduct, assaulting people, has always been unlawful at the time of the founding, as it is today. We're talking about whether or not we can ban possession of firearms. And I am suggesting that if we look at the founding era, there were no laws prohibiting simple possession of a firearm by members of the political committee, the members of the political committee. Again, that is the lesson that Bruin says, I should say that is the analysis that Bruin asks us to undertake. And if you look at the laws to which the government is pointing, they don't do that. They do not answer the how and the why that Bruin instructs that we must look for. I just want to make one other point, because the government relied on this heavily in their brief. The proposals in the ratification conventions in Pennsylvania, New Hampshire, and I guess it was Massachusetts. New Hampshire had a proposal for disarming persons who had engaged in rebellion. Massachusetts had a proposal for preventing the government from disarming peaceable citizens. Pennsylvania had a similarly drafted proposal. None of those proposals passed, and none of that language made it in to the actual Constitution. And at the time of the ratification, none of the 4 state constitutions that had parallel provisions had any such exceptions, nor do we see those exceptions in the state constitutions that immediately followed ratification. Again, while it might be a policy that people in this room support and can get behind, that just wasn't the way the right was conceived of at the time of the founding, and it's not the right that was enshrined in the Constitution, which, again, Mr. Kim relied on, I don't know, English common law from the 1600s. Bruin instructs, by the way, that that is not particularly relevant to this analysis. Before the English Bill of Rights, the only there was a prohibition for people who were dangerous to have weapons. However, in the English Bill of Rights, that language was definitely constrained and only provided a right as against the Crown. Parliament could, in fact, pass laws determining who could have firearms. That is what is written in the English Bill of Rights. That is not what is written in our Bill of Rights. The Bill of Rights here does not contain the caveat that applies there, which limits the right as instructed by law. That was expressly rejected here. And Bruin teaches us that we cannot, at this late date, put in language in our Constitution and concepts in our Constitution that didn't exist at the time of the founding.
You haven't pointed to any laws at the time of the founding that restricted firearms possession other than laws that we would now deem repugnant, such as laws banning certain religions or races from carrying firearms. Does that mean that no firearm dispossession tests would satisfy Bruin's text, history, and tradition test?
Your Honor, sitting here today, I can't say I've canvassed the entirety of colonial history. I've done my best. Like Mr. Kim, I studied very hard this weekend, and I think there is an ongoing historical debate about this. But I will note that it isn't my burden to find the historical analog. What Bruin teaches is that once the conduct falls within the scope of the text of the Constitution, which Mr. Rahimi's conduct clearly does, the burden shifts to the government to come forward with an appropriate analog.
Let me just ask one follow-up question then. So let's say your client was one of the insurrectionists who stormed the Capitol on January 6th. That would align, I think, with some of the prior historical laws that we've been talking about today. Would we be allowed to have the Texas County judge issue an order taking his firearm away from him in that case? Is that a close enough analogous situation?
Well, I think actually courts will be adjudicating very soon whether or not that constituted an insurrection. And there certainly were...
Assume for hypothetical purposes that people storming the Capitol were insurrectionists.
Just among us.
Just for today.
Yeah, no. There were laws at the time of the founding for disarming rebels and insurrectionists. There were not laws banning possession for people who were deemed dangerous on an interpersonal level and did not pose a threat to the state. And I just want to note, I see my time is up, but if I may make one more note, Your Honor. Even Congress doesn't think that all persons subject to protective orders cannot be trusted with firearms. If you look at the statute, 922 G8, it provides that if you're a law enforcement officer, notwithstanding the fact that you are subject to a protective order, you can carry your firearm. So this notion that being subject to a protective order reflects some profound danger is actually not substantiated by the statute itself, particularly because the statute applies even in situations where the protective order does not have a finding of potential threat or dangerousness. I see my time is up. Thank you.
Mr. Kim, you have 5 minutes for rebuttal. I assume you want to use your 5 minutes?
Yes, I do. I didn't get an applause earlier, so we're both of you.
I think they thought we were
try to earn one now.
They thought you weren't going to take your rebuttal.
I think a very telling exchange that we saw was when Justice Biden, you asked whether Ms. James thinks the prohibition of gun possessions by felons or mentally ill are still constitutional. And she said, it looks like it's an open question still. That displays the lack of a limiting principle to Ms. James's position and the Fifth Circuit's decision in Rahimi. Basically, everyone has a right to a firearm. And so felons, mentally ill, children, subways, schools, there's no limitations under that principle if you just read it as all people have a right to bear arms, which clearly this court has not done. And so I think that was quite telling. Ms. James also noted that I focused on English common law. I did that only to show that I had actually done the reading this weekend. The analogous laws continue through the founding era of this country. There are many state precursors to the law-abiding and responsible citizen limitation. There was laws disarming loyalists who refused to swear allegiance to the new republic. There were the rebels who participated in the Shays Rebellion.
Mr. Kim, what do you make of the Ms. James's point that all of those laws involve sort of a threat to the republic, to the state, and not a sort of threats on an individual basis to, individual safety, like in this statute.
It's a distinction without a difference. They were imposed because these individuals posed a danger to the community at large. And what is the community at large? They're made up of individuals because if they possessed guns, they pose a danger. I think that's a distinction that Ms. James tries to draw because they have to try to distinguish every one of these precedents. There are laws and were laws that were designed and to limit and regulate firearms possessions against individuals who pose a danger to other individuals, the surety laws. She tries to distinguish that by saying, well, that's different because it allowed you to possess a gun if you put up a surety. But the standard is to look to see whether there are relevantly similar precedents. It doesn't have to be a twin. It doesn't have to be a straitjacket. And so these are analogous statutes that go back all the way to the English common law, but right up through today, as 48 states have imposed this restriction of individuals who are either the subject of a domestic protective order, the prohibition of firearms, or allowing courts to prohibit them. So it's a long-standing and deep-rooted tradition that continues to today.
Even if it doesn't have to be a twin, do you have any historical analogs involving the permanent disarmament of a person based on their conduct?
Well, first of all, 922G8 is not a permanent disarmament, but there are precedents from the Revolutionary era that did, as I noted earlier, disarm loyalists who refused to swear allegiance to the new republic, which is a similar restraint of firearms as 922G8. There was also the rebels who surrendered their arms after the Shays Rebellion, which I also had to read about, surrendered their arms as a condition of being pardoned. So there have been precedents of both long-term and wholesale prohibitions of gun possession.
I understand your argument about dangerousness, and I can certainly understand why on these facts you could make an argument that Mr. Rahimi's conduct evinced dangerousness. But what about a situation where there was just a threat? Someone threatened another person. In your view, would that rise to the level of dangerousness that would justify being able to take someone's weapon away under the statute?
Not in my view. 922G8 requires there to be a notice and a hearing and a finding that involves a finding of dangerousness. So yes, if those elements are met, then you can disarm them and consistent with the Constitution.
What if the finding of dangerousness wasn't based on, following up on Justice Racanelli's question, isn't based on an individual's action, but his association with a certain type of behavior, say, for example, Jets fans? Is it possible to say they, by and large, long-suffering, largely alcoholic, and therefore maybe have a disproportionate propensity towards violence, particularly towards visiting teams, and therefore we're going to restrict all of them from firearm possession, at least during football season? Would something like that be appropriate?
I think that type of example would have trouble finding even relevantly historical analogs. Perhaps in Patriot country it would, in the Massachusetts law, but I'm not sure that would apply. I think this, I see my time is up, but this exercise that the Fifth Circuit engaged in and that Ms. James engages in, which is looking at historical analogs that clearly are relatively similar, and say, well, this one's too old, this one's too new, this one didn't apply to too many, this one applied to too many people, this one applied to not enough people. It's like the Goldilocks choice and looking for ways to distinguish these precedents. That's not what the court directed in Bruen. And I think if you were to present the statistics today of how many people suffer from domestic violence and guns, I think even our founding fathers, it was a long time ago, they were mostly white men, and it was 250 years ago, before the internet, before Al Gore invented the internet, but still I would say they weren't mad. I think they would say a restriction on guns, the possession of guns to people who are subject to domestic protective orders is constitutional. Thank you, Your Honor. Your Honor.
Thank you, Mr. Kim. The case is submitted.
Please rise. The mock Supreme Court of the United States now stands adjourned. The court will reconvene on October 7th, 2024 at 10 a.m.
So I don't know. How about an argument that an attack against domestic partners, mothers and fathers, is an attack against the polity in the state? I didn't study all weekend. I didn't do the reading, but I remember something about the founding fathers and the philosophers of the 18th century saying that the state and the polity began with the family. So it's probably a bad argument, but it just came to mind. I'm Joanna Hendon. I'm a member of the OAD board and the host committee, and it is my distinct pleasure to talk to you about my friend Danny James, whom I've known for more than 20 years. To all of us who know her, to her family, her clients, all of us, Danny is a beacon. And that's an overused term, but I looked it up today. My lift was lighter than Danny's and June's. I looked up the word, and a beacon means a fire or a light set up high in a prominent position as a warning, signal, or celebration. A fire or light set up high as a warning, signal, or celebration. That fits Danny James to a T. Danny can be a warning signal. She has an edge. Danny is relentless when it comes to fighting for what is fair. She is ferocious when she is right and when it matters. And Danny is always right when it matters. Sorry, Tracy, Phoebe, wherever you are. Danny is also a light set up high for celebration. She is brilliant, warm, gracious, and kind, unfailingly so. The Gould Award is given annually to, quote, two of the nation's premier appellate lawyers, and Danny James is assuredly that. But before there's an appellate argument, before there can be an appeal, there is the work that trial lawyers do. Every issue that is heard on appeal is one that must be properly preserved below. Many of you out there spend your careers making a record in the trial court in order to persuade the judge you're right, if you can, but to preserve issues for appeal where you are not successful. And my remarks here as I introduce Danny are directed to those of you here tonight who may not yet have done this yourselves or even seen it done. Making a record, preserving issues for appeal is one of the most demanding aspects of our profession. Why is that? Because it requires you first to identify every legal argument available to your client that matters on core issues as early in the case as you can. That takes tremendous skill, intellect, creativity, and hard work. But then you have to get up on your feet and actually make those arguments to the trial court. And that's challenging both because you have an adversary. In our business, it's often the government. It's usually the government. And the job of your adversary is to defeat every one of your arguments. But the job is also challenging because you have a judge who may not like your arguments or want to hear them, may not want to spend the time on them that you need him or her to in order to make your record. There is no hotter crucible for this than at the end of trial at the charging conference when both sides have presented their case. Barry Burke, you know where the story is leading. And the lawyers are now arguing about the applicable law and how to instruct the jury. It's fourth down and there's 1 yard to go. All the evidence is in. We're about to have closing arguments and the lawyers need to know how the jury's going to be instructed. It's almost always the morning or the night before closing arguments and deliberations. You're tired, the prosecutors are tired, even the judge is tired, or maybe he's just tired of you and your case. But it's a rough road to hoe. You have to get the charge right. What you do in that setting is as important as anything you've done up to that point since you got hired by your client. You have to get the charge right, and if the charge is going to contain errors or what a reviewing court might consider errors, you need to make sure the trial court's rulings are crystal clear, so you have your record on appeal. And for those of us who have had the thrill of seeing Danny James in action in trial, one charging conference stands out, and I'd like to tell you about it before we present Danny with her award. In 2018, Danny began representing Theodore Huber, a young man charged with a raft of complicated insider trading and fraud counts. Danny's client worked at a fund that analyzed the value of life sciences and pharmaceutical companies. As part of the fund's work, Danny's client and another defendant spoke with consultants whose job it was to learn about the developments at government agencies that make decisions affecting Medicare and Medicaid funding. If you know that the government is weighing certain changes to Medicare, Medicaid reimbursement, it can impact the value of the companies you're analyzing. The case was called U.S. v. Blazak. All 4 defendants contended they were wrongly accused. They had not traded on inside information, and they were not guilty of insider trading, they argued. And beyond that, the information itself, the agency's views on proposed changes to Medicare and Medicaid funding, was not property within the meaning of the fraud statutes under which they were charged. These are highly technical, but potentially dispositive questions of law for which the Second Circuit law at the time was not favorable. But these are arguments that a creative and dogged lawyer might have felt could one day have traction in the United States Supreme Court. The Blazak trial lasted 4 weeks. At the conclusion of the evidence, it was time to face the government and the judge and the charging conference. The defense huddled. Who would they entrust with the job of making difficult but possibly dispositive legal arguments before Judge Kaplan, where circuit law so clearly favored the government? And this is a spectacular set of defense lawyers we're talking about, from Allen and Overy, from Sherman and Sterling, the Federal Defender's Office, and from within the ranks of Danny's own firm. Each of these lawyers was a star. The decision about who to send into that charging conference was not difficult for the defense. It should be Danny. Why? For the reasons you've seen here tonight. She is the calmest and coolest of advocates. She is lights out brilliant, but she is also unafraid. She's unafraid to press difficult points and arguments, even unappealing ones, no pun intended. How should the jury be instructed on the definition of fraud? How should they be instructed on the definition of property? She stood her ground in that well that morning on little sleep, her nerves shot, no doubt, and battled the government and sometimes even the judge, politely, patiently, graciously, winning some arguments and losing others, but not giving up until she had made her record. And if you think it sounds hard just listening to me describe it, wait until you try and do it. What happened next? Theodore Huber is free today. After 4 days of deliberation, without a single note, the jury acquitted the defendants on all of the insider trading counts. And following appeal after appeal, the Supreme Court of the United States, following a little decision known as Bridgegate, acknowledged the defense argument that there was no property right in the type of information at issue in the Blazak case, which placed all of the counts of conviction in jeopardy. And these were 4 defendants who were convicted of those property counts. They were sentenced, and at least one of them had started to serve his jail time because he didn't want to wait for the appeals. He just wanted to get this behind him and move on. So ultimately, the district court dismissed all of the property-based fraud counts, and the only counts left for retrial were some conspiracy counts. And this summer, the government agreed to dismiss even those, again, based on Danny James's spectacular advocacy, a critical phase of which occurred on that 1-yard line, Danny, 5 years ago. The Blazak case helped make and unmake law in this circuit in ways that will help the wrongly accused for years to come. I am proud and thrilled to honor Danny with this year's OAD Gould Award for Outstanding Advocacy.
Arguing about those jury charges wasn't as hard as getting up here and arguing that there should be no regulation of firearms possession whatsoever, ever. But I did it, and I almost convinced myself I was right. Thank you, Joanna. She might have taken some creative liberties there and given me more credit than I deserve, but I just want to say how honored I am to receive this award. I've been in the audience and I've seen this award given to so many who I think of as greats of this bar, and to be considered in the same breath as some of those advocates is truly humbling, and I'm eternally grateful. And I wouldn't be here if I hadn't had the extraordinary opportunity to learn from some of the best and most passionate advocates, many of my partners who are here today, and many of my colleagues in what I submit is an extraordinary defense bar in New York City. You all inspire me every day to do this work and to do what we can to bring fairness to the system and to hopefully ensure that the criminal justice system actually spits out justice. And I also obviously want to thank my husband, Tracy. Without your enduring support, encouragement, and patience, none of this would be possible. And of course, I would be remiss if I didn't thank my daughter, Phoebe, who bears the brunt of the long hours and emotional toll that this job can sometimes take on us. And I hope tonight, maybe you think some of it's worth it. And maybe you'll stop wondering why people actually pay my hourly rate to hear from me when you, just reject everything I have to say for free. I hope I've made you proud today, because you make me proud every day. Thank you.
Hi, everyone. First of all, congratulations to Danny. Very, very well deserved. And good evening. Wasn't that terrific? Weren't June and Danny terrific? I have to disagree with Nick, who said that this is one of the best legal fundraisers. I actually think this is one of the best events New York City has to offer. I might even enjoy it more than Shakespeare in the Park, personally. So, as it is also, I think, a fitting tribute to the oral advocacy that OAD performs every day on behalf of indigent appellant defendants across the city. I am so proud to serve as a member of the board of OAD, and I'm also equally proud to present this award to my dear friend and partner, June Kim. So my name, by the way, I don't even think I introduced myself. Lisa Vicens. I'm a partner at Cleary Gottlieb and also a member of the board of OAD, as I just mentioned. I have been very, very grateful to know June for a number of years, serving together as partners at Cleary Gottlieb, and I'm so happy to see so many of his friends and his colleagues, current and former, here today. In fact, I think most of the justices that are here either served with or were supervised by June when he was at the when he was at the Southern District of New York as an acting U.S. attorney and as an assistant U.S. attorney. So all of you in this room know that June is an amazing attorney. In fact, I think it's fair to say that for the last 25 years, he has demonstrated time and again just what an amazing, smart, and just brilliant advocate that he is. We all know that he's basically excelled at everything that he's ever done. He served 2 times at the U.S. Attorney's Office for the Southern District, serving in roles such as the Chief of the Criminal Division, Deputy U.S. Attorney, and as acting U.S. Attorney, where he supervised approximately 220 assistant U.S. attorneys in significant civil and criminal matters. He's also been a partner at Cleary Gottlieb for 15 years, where he's represented individuals and companies on the most sensitive and difficult of matters. He is a trusted advisor to his clients, and they turn to him in times of crisis. He's also someone who guides his clients always through what I would say are really those kinds of decisions that require someone who you can go to and who can bring you a sense of calm and who can really you can trust to advise you in the right and guide you in the right direction. It's for that same reason that he has been a trusted advisor to the firm and that he was elected to serve on our firm's executive committee. So June, I have to admit, in private practice, has not had as many opportunities to be in the courtroom. In fact, I think maybe the last time he's been in a courtroom was when our former partner and now Judge Louis Lyman was sworn in. And of course, you've probably all heard some of the stories, in fact, probably frequently and from June himself, about his most well-known experience in the courtroom. And that was when he participated as a member of the team prosecuting John Gotti Jr., which led to, I believe, not one, but 2 hung juries. In all seriousness, though, June actually is a terrific advocate, and again, one of the smartest people I've known. He himself has tried over a dozen federal jury trials, and he's also argued on numerous occasions before appellate courts, including the Second Circuit, although I think this may be the first time that he has argued before the Supreme Court. Through all of these experiences, he has developed a very well-earned reputation for excellence and integrity. And it is that reputation that led him to be appointed by the New York Attorney General, Letitia James, to conduct an independent investigation of former Governor Andrew Cuomo. As James said in her own words, he and his co-counsel, Ann Clark, are independent legal experts who have decades of experience conducting investigations and fighting to uphold the rule of law. So, as you can imagine, it was no surprise to me when OAD selected him to be a recipient of this year's Gold Award. However, it was a surprise to June, who actually came to me and asked me, do you know whether OAD selected me because of my sense of humor? And do they expect me to be funny tonight? Well, I told June that even though he is one of the funniest people that I know, and that is very true, that I could assure him that, in fact, OAD did not select him to be funny. And I'd like to say that I think tonight that he proved me right. So with that, I'd like you all to give a big hand to my friend and partner, June Kim, as this year's recipient.
All right, thank you, Lisa. She did confirm through her description that I have not seen a real courtroom in years. That clearly, it was the humor, it wasn't the oral advocacy. I'm really glad I got to do this mock argument already on our firm's website. Numerous oral arguments before the Supreme Court. Mock, paren. Thank you, Lisa, for the generous and kind remarks. One of the great pleasures of being at Cleary over the last few years since I've returned has been working with Lisa, who many of you know, such a talented and dedicated advocate for our clients, and combines sort of the kindness and smarts and toughness in the great tradition of the advocates here and at Cleary. So thank you for that, and thank you for my colleagues from Cleary who are here. I want to also congratulate my co-honorees tonight, Danny James and Christina Duggar and Auric, all incredibly well-deserved honorees. certainly more so than me. In particular, Danny James, who is a formidable adversary, as you've seen. The last time that I was on the other side of the table with her, I was back at the U.S. Attorney's Office interviewing a certain former mayor of this city who was under investigation at the time. I won't name who it is. He's just a really tall guy, tall white guy. But as you might imagine, she was a formidable adversary, but always with class and grace, as you've seen. Not surprisingly, when I was a junior at AUSA, she was already a seasoned organized crime prosecutor, and we all looked up to her. Everyone seemed to respect and admire her, the judges, our colleagues, defense counsel, interpreters, everyone. And I remember thinking, maybe one day I could be like Danny James. And I've been chasing that dream unsuccessfully ever since, including tonight. Well, congratulations on a well-deserved honor. I actually think you're also going to win in the real Rahimi case. At least that was my conclusion reading it this weekend, and then as I was shatzing this whole thing earlier. Last but not least, thank you to Caprice, Nick, the board, the lawyers and staff of OAD. It really is a true honor to receive this recognition from OAD, although you certainly made me work for this. I'm not sure how I'm going to bill the hours from this weekend, reading up on old English law, crossbows, armor. I'm hoping that Office General covers that. But we'll see. There may be an internal investigation going on at Cleary as we speak. And being invited to this, I feel it's a little bit like being invited to a dinner at a great private club that you never thought you could get into, you think was too cool for you, and then you accept and they tell you you have to cook dinner, mix the cocktails, and it's going to be an open kitchen. You're going to invite all your friends, and they're going to watch, and they're going to laugh. And then they're going to hope you make mistakes. So no pressure. Except it's not like that. There was actually no dinner. So, I think heavy hors d'oeuvres is what it's called. And I didn't even get a cocktail, so I figured that would not be a good idea. But in all seriousness, it is a great honor to be recognized by this great organization, OAD. Even its name is impressive, Office of the Appellate Defender. It sounds like a Marvel superhero office, Voltron, Defender of the Universe, Caprice, from the Office of the Appellate Defender. But in reality, it is an office full of superheroes doing heroic work. And that's why I'm particularly honored tonight to be recognized. It, as we've heard, performs a critical mission in our justice system. Not when we walk into our courtrooms, Lady Justice is blindfolded because all are supposed to be treated equally under the law. But we all know that the reality is that the system can seem stacked against the poor and the powerless, and it's organizations like OAD that steps into that breach, or as you said, gets in the way to fill that gap between our aspirations and reality. So thank you for everything you do. Thank you for honoring me. It's been a real pleasure. Thank you.
All right. Note to self, try not to go after June Kim speaking. So I'm James Lunam, partner at the law firm of Jones Day, and it is my great pleasure to introduce tonight's final honoree, our Chief Justice, Christina Duggar. We are in the home stretch. As many of you know, Christina is the Global Chief Compliance Officer and firm-wide operational risk executive at JP Morgan Chase. Sounds stressful. But obviously, Christina is more than up to the task. She's received a lot of awards over the years, and introductions like this one focus on her time as a prosecutor at the Eastern District of New York and her many high-profile prosecutions, including the prosecution of New York State Assemblyman William Boylan Jr. on corruption charges, and the retrial of Lemrick Nelson for the civil rights murder of Yankel Rosenbaum in connection with the 1991 Crown Heights riots. And rightfully so, those were very important cases. But I want to tell you about a different case that Christina prosecuted, and this comes care of Jimmy Buthorn, who was an agent that Christina worked closely with, and I believe is now with JP Morgan.
He is.
And so Jimmy sent me a New York Post article on one of Christina's cases that was titled, "Brooklyn Kingpin's Reign of Carnage." And the article reads, and I'm not making this up, quote, "He was New York's killing machine. John Bloody Hatchet Hatcher, the brother of a minister, has admitted to involvement in more than 80 shootings, including 30 homicides, while operating a notorious gang that made tens of millions of dollars selling crack cocaine and marijuana. During a 2-decade reign of terror, Hatcher and his gang, the Rugby Boys, littered the streets in the heart of Brooklyn with victims and bodies," end quote. Christina prosecuted Hatcher, one of the toughest gangsters in New York, and together with her team, Hatcher took one look at Christina and knew his fate was sealed and confessed to all of it. And with the help of the Bloody Hatchet, Christina and her team dismantled one of the most violent street gangs in New York history. So my message to any non-compliant JP Morgan bankers, or JP Morgan bankers that are even thinking of being non-compliant, have you lost your mind? Proceed at your own peril. So a little bit of background on Christina, a little bit more of the bio. Christina graduated from Columbia, where she was a captain of the women's basketball team. Then Cornell Law School, where she was managing editor of the Law Review. And Christina started her career at a law firm, Rogers & Wells. It no longer exists, was acquired by Clifford Chance, and we'll come back to that at the end of this introduction. And then she clerked for the Honorable Judith Kaye, Chief Judge of the New York State Court of Appeals. In 1999, Christina became an assistant U.S. attorney for the Eastern District of New York and held various supervisory positions, including the Chief of General Crimes, where she mentored many lucky AUSAs, including me. And Christina had this amazing ability to focus on the potential for each individual AUSA, what they were good at, and then sort of spoke to each of us as if we were doing that and living up to that potential all the time. And what it did was it instilled an absolute desperate desire not to disappoint Christina. And it made us all better for it. In 2009, Christina joined JP Morgan for the first time as an assistant general counsel and worked there for 3 years before being asked by Loretta Lynch to return to EDNY as the first assistant. And at the time, Loretta cited Christina's commitment to justice and personal integrity, which in my experience are beyond question. Christina returned to JP Morgan Chase in 2014, where she obviously excelled, holding various jobs, including the head of government investigations and regulatory enforcement, before her current job as the global head of compliance. In her free time, which I'm sure there's lots of, Christina's been active in giving back to the legal community, serves on the board of directors of the Citizens Crime Commission of New York City, has taught at NYU, Brooklyn Law, and Columbia. Now I want to return to Christina's time at Rogers & Wells. I also started my career at Rogers & Wells. I think David Meister was here, who has spent time at Rogers & Wells as well. And I remember thinking what a big deal the managing partner was when I started there. And it wasn't because of his huge corner office, and it wasn't because of his title, but because the soda machines at the firm were stocked with Tab. It was a soda I didn't even know was in production anymore, but because he liked it and drank about a dozen cans of Tab a day, they stocked the soda machine with Tab. And I remember thinking, wow, if you get to a point where they're stocking the soda machines with the sort of obscure soda you like, you've made it. Like, there's no question you've made it. Along those lines, I've come to report that JP Morgan is now stocking their soda machines with Fresca. And they're doing it because it's Christina's preferred beverage. So there's no topping that. You have reached the pinnacle of the profession, but hopefully a very close second to the Fresca and the soda machine. We are so grateful for your willingness to be part of this event, for helping us raise support for the Office of the Appellate Defender, and it's my honor to present you with the Office of the Appellate Defender Counsel for Justice Award.
You want your notes? Thanks so much, James. That was really kind. Appreciate those words, and it was always a pleasure supervising you at the U.S. Attorney's Office. In retrospect, I should have probably paid closer attention to what you were doing, but you seemed like you were on it, and you had good judgment, and nothing really went wrong. So I guess it was an overall success. But I'm really honored and humbled to receive this award tonight, especially from an organization that really is committed to serving justice on a daily basis. Thank you, Caprice and the OAD family. It really is a requirement that we give zealous advocacy and ensure that is something that everybody has when they enter the appellate arena, whether you can afford a lawyer or not, and you do that and ensure that our justice system works as intended. And I'm really, as I said, honored even to be in the room with you all today. As somebody who's had my fair share of time in front of very cranky appellate courts, including Justice Sotomayor up there in the Second Circuit, and I even had an opportunity once to get lambasted in front of the Appellate Division First Department when I was working for Harlem Legal Services back at Rogers & Wells on a pro bono assignment. So I know firsthand how hard it is to do a good job as an appellate advocate, all the work that goes into it. I'm really impressed by the performances tonight of Danny and June, because even a mock argument takes a ton of work, as we've learned. And so you provide that zealous, top-notch legal representation every day, and I stand in admiration of all the work that you do. I just, you mentioned that I had clerked for Judge Kaye, James, and so was so happy to see one of Judge Kaye's fellow judges on the bench, Judge Carmen Saparik, here tonight. But even before I saw you tonight, Judge, I was thinking I'd love to, just in my mind, dedicate this award to Judge Kaye. I had a ringside seat to see what real grace and commitment to justice looked like every day, clerking for her for 2 years, and saw lots and lots of tremendous appellate arguments in the context of that assignment. But really, she was the embodiment of justice and how to be a part of the justice system in a way that really made a difference for all people. And so she really showed me the way for the rest of my career. And I wanted to dedicate this award to her. So thank you very much.
So there is actually one more very important award, so please bear with us. OAD began its reinvestigation project in 2007 to provide immediate review of all cases, to look for the hallmarks of wrongful convictions, and to launch appropriate challenges. 1 year after the reinvestigation project started, which was led then by Anna Heger, who I think might be in the room, OAD began representing Ricardo Jimenez. on his direct appeal. 17 years after a shooting in the Bronx, Mr. Jimenez was arrested and charged with murder. He was convicted at trial in large part because of Brady violations and the corrupt testimony of a person serving a very lengthy prison sentence. Mr. Jimenez was sentenced to 22 years to life in prison. He was ripped away from his mother, his wife, his children, and his community. Through the years, many attorneys, many OAD attorneys, played a role in advocating for Mr. Jimenez. Anna Heger and others interviewed witnesses across 6 states. But what was most compelling about Mr. Jimenez's story was the hope that he held on to with the support of his family and the advocacy he did for himself. Mr. Jimenez filed his own habeas corpus petition in federal court. And then OAD extensively supplemented that petition, and finally, in the summer of 2022, a federal district court judge granted that petition. Last fall, after serving more than 16 years in prison, Mr. Jimenez, a son, a father of 7, and a husband, finally came home. We are honored to have Mr. Jimenez, his wife Demetria, and his 2-month-old daughter here with us tonight to present him the Beacon of Hope Award to celebrate his enduring hope, his strength, and his resilience. Please join me in celebrating Mr. Jimenez.
Excuse me for a minute, please. I never thought I'd be up here. You know, just want to say thank you to Andy Heger, Rosemary Herbert, OAD. You know, 'cause I never thought I'd be up here. I never thought I'd be in the street again. You know, they gave me hope, and oh man, I'm sorry. I just want to thank everybody from the OA team, and like I said again, especially Ms. Heger and Anna, who believed in me, and they still did. I used to always ask, I know you're going to give up on me, you know. Every time we got denied, I used to always, you know, tell them. There's a couple times I got, you know, upset. I know y'all going to leave. Once they deny it, y'all just going to go. And they did, and they stood there all the way to the end. I still remember that last day. November 14th, when I called my wife. She told me it's over. She's crying. And the police tells me, Jimenez, you gotta get out of here. I look at him like, I'm going to the yard. He's telling me, you gotta get out of here. I don't know who you're talking to, but I'm going to the yard. My wife is saying, you out of here. She tells me, the judge released you. Police say, you out of there. I said, you ain't gotta tell me again. I ran to my cell, came out with my pictures, and my legal work, and I was out of there. Like I said, he had to tell me again. Once my wife told me the judge released me, they didn't have to help me or rush me or nothing, you know. And it was hard being in there, hoping I'm gonna make it home one day. And made a little baby, a baby girl. I've been wishing for a baby girl for 55 years. I got all boys, and God gave me a girl. And like I said, I thank the OAD and Mr. Anna and Ms. Heger, who was there by my side for the whole thing. Thank my wife, my mother was there for me. She helped me through this every twice a week visit. And I was like in every Attica to Clinton to Comstock. And she never gave up. She used to always tell me when I used to cry to her, I'm done, I'm not coming home. And she would tell me, just don't give up. With that, I just, like I said, and thank God. That's basically it, and I just want to thank y'all for having me here. Like I said, I never thought I'd be in a room like this, especially with y'all people, you know. But I thank y'all, and God bless everybody.
So please bear with us. The final act of tonight's program is about to begin with the mock Supreme Court's deliberations. Chief Duggar?
We'll now proceed with deliberations in United States versus Rahimi. Justice Ramchandran, we'll start with you.
At the founding, all kinds of people who were viewed as dangerous were prevented from owning guns. Preventing domestic abusers from owning a gun where a court has determined they're dangerous enough to warrant an order of protection falls squarely within that tradition. Bruin requires the challenge law to have a historical analog, not a historical twin. The respondent has asked us to interpret Bruin to foreclose any gun regulations that did not exist at the founding. But at the founding, domestic violence was not a concept, much less a crime. As society's tolerance for domestic violence has changed, the laws governing domestic violence have in turn changed. Section 922 G8's restriction on gun ownership reflects our current understanding of what makes a person too dangerous to own a gun and falls well within the historical parameters that Bruin contemplates. I rule in favor of the petitioner.
Thank you. Next up, Justice Racanelli.
I did not have something prepared. I also rule in favor of the petitioner, although this was distressingly close, which I guess is a reflection of our current Second Amendment jurisprudence. I think the historical record, as in most cases, one can make of it what one wants. But I do think there is sufficient precedent in the historical record to allow for this restriction, so I also rule for the petitioner.
Justin Bayman.
I vote to affirm, actually. I think that it is a close call, but these determinations in connection with protective orders are often made with minimal due process without the defendant's ability to challenge them. A domestic order requiring someone not to harass, stalk, or threaten an intimate partner is an order that simply requires them to follow the law. If they possess the gun and use it, they may, of course, be prosecuted for violating the law as well as the order in multiple ways, and the state can enhance the sentence for using the gun. But there isn't a sufficiently similar analog to uphold this restriction without effectively abandoning the test that we just implemented the last term in Bruin.
Thank you. Justice Graff.
I imagine at this point in the evening, the judicial virtue that will be most appreciated is brevity. I will say we are fortunate to live in a country that has a rich political history and a diverse tapestry of views. Having exhausted my capacity for cliche, I'll pivot to the fact that our jurisprudence has chosen to focus on a very narrow slice of that history. Such that we are limited to considering the opinions and legislative action of people who, as June's statistics and Sarah's thoughtful question reflect, are statistically much more likely to have been domestic violence perpetrators than victims. Given that, I think that the admonition to not let this guidance be a regulatory straitjacket counsels in favor of a broad reading of what's analogous. So I also vote in favor of petitioner.
Thank you. Justice Diane Danda.
I want to start by reminding this court about the necessity for 922G8. The objective of the provision is largely guided by principles about public safety because there's a strong correlation between domestic violence and acts of gun violence, which was so eloquently laid out by Mr. Kim. Regulating the possession of firearms by individuals who are under a restraining order where judges determine that the individual poses a significant danger to the safety of another is crucial to protecting the victims. Limiting access to firearms for individuals who pose a danger is a logical step in reducing the risk of further acts of violence. The Second Amendment right is not absolute, and the government's interest in protecting society is appropriate and reasonable, as discussed in Heller and Bruin, and that statute is narrowly tailored to address this problem. I want to just note one notion about that the respondent raised, the notion that the founders viewed the phrase, the people, broadly and unambiguously, is rather ironic. This country's history has always placed a limitation on who encompasses the people. It wasn't originally considered to include people who look like me or my gender, and it was evidenced by the need to explicitly address the right to vote for women and people of color in the 15th and 19th Amendments. Rule in favor of the petitioner.
Thank you. Justice Coyne?
I rule that the Fifth Circuit erred in applying the court's decision in Bruin. A historical twin law is not required in order to uphold this law today. To hold otherwise would hamper the government's ability to protect people from newly recognized threats and would restrict their authority to regulate gun possession to periods when our government disregarded many forms of violence. Indeed, the Fifth Circuit's analysis mistakenly shifts the focus from where it should be on the dangerousness of the actor to a historical analysis of victimhood. This, of course, leaves out in the cold those domestic partners, the vast majority of whom are women, whose harm at the hands of their partners this country has routinely and regularly ignored. Essentially, the Fifth Circuit has held that if we didn't protect you at the founding, we won't protect you now, never mind that you had no voice at the founding. That said, the petitioner has gone too far, suggesting that this court should adopt a law-abiding, responsible citizen test, no matter how many times Justice Bybin might have referred to it in prior opinions. That is indeed too vague and ambiguous. As my sister and brother justices have noted tonight, no one seems to know where the line is for a law-abiding and responsible citizen and who decides who has crossed it. Those are good and important questions, but we need not answer them today. Wherever the line is, it is quite clear that an individual subject to a domestic violence restraining order described in this statute is very much on the wrong side of it. I vote in favor of the petitioner and reverse the order of the Fifth Circuit and vote to remand. I have no idea if we're remanding anything, but I've always wanted to say that.
Thank you, Justice Coyne. Justice Capone.
I also rule in favor of the petitioners. Very much like my colleague, Justice Coyne, however, I reject the petitioner's premise that the scope of the Second Amendment right is limited to responsible, law-abiding citizens. I think that is an amorphous and dangerous concept for us to apply going forward. I think our precedents are clear, including Heller, that the right to bear arms belongs to all members of the political community, but that is not the end of the inquiry. The question is whether the regulation of that right is consistent with our historical tradition of regulating firearms. I won't repeat what many of my colleagues have said, but I do think there are ample historical analogs, not twins, but analogs for that regulation. I think Bruin allows for us to compare this law to analogous laws, whether or not they deal with domestic violence, and whether or not they targeted dangerousness on the basis of an individual being a danger to the state or to other individuals. As Mr. Kim articulated, I think that's a distinction without a difference. So for those reasons, I would also vote to reverse.
Thank you. Justice Bybin.
Abraham Lincoln said the Constitution is not a suicide pact. He was right. I rule for the petitioner.
Very well. As the Chief Justice, I get Fresca, and I am not required to explain myself. In the interest of time, I will just say I'm ruling in favor of the petitioner as well. So we are at 8 in favor of the petitioner, 1 dissent. As the most senior junior justice, Mr. Bybin, we will have you write the opinion of the court. And that concludes our session today.
Thank you so much for joining us, and I hope you will join us next year, October 7th, 2024. Thank you for coming.